Good morning or afternoon, everyone. You're on the Gray Plant Mooty webcast for Barbarians at the Gate. This is Kirk Reilly. Quite frankly, we're going to give a minute or two to allow folks to fully sign in and get engaged. We appreciate those of you that are perfectly on time, but we'll wait about a minute or two and then we'll start our presentation. Thanks. At the Gate, this is Kirk Reilly, who's going to lead this presentation along with my associate, Justin Sallis. First of all, thank you for attending this. I'm hoping that most of you have dual screens so that you'll not only learn a great deal about the attorney-client privilege, but if at times you need be, you can probably also set your fantasy football lineup or check out what's going on at Amazon.com. First of all, this is a high-level presentation to in-house counsel of franchisors. We are really going to try to fit this to your lives. And quite frankly, as you'll see in a minute as we go through the slides, you have some unique challenges as in-house counsel at franchisors that outside counsel may not actually have. So at the goal of our presentation, we can't do everything in an hour, but our primary goal is so that at the end of this, your head and your gut will have a buzz when you experience or encounter issues that you'll think, you know what, the privilege is implicated, there may be a better way to preserve it here. Now on the screen, you'll see a brief bio of myself, Justin Sallis, who will be participating hopefully about 50% here, and we're both litigators with Gray Plant. I happen to be one of the co-chairs, and I've done this for, unfortunately, quite a while, and Justin is a fantastic associate in our DC office, and the only problem, which we don't have time to get into, is that he's a Green Bay Packer fan. All right, let's get started. What are we going to be talking about this afternoon or morning? First of all, your curse. You are in-house counsel. The things that are troubling to us as we prepare for that is that you face dual roles and you also face multiple clients. We're going to be talking about those. Justin's going to talk about the 3 myths about the attorney-client privilege that we hope we can dispel today. We're going to talk about the common interest privilege, which is a privilege that attaches to non-clients, third parties that normally there'd be a waiver, yet there's a special relationship that can, in fact, protect communications. Justin will talk about the work product doctrine and franchisors. Then we'll get into what we call the real world, brief overviews of internal investigations, M&A, crisis communications and PR firms and other specialists. My personal favorite, there may be some sarcasm there, working with insurers. And finally, a brief nugget on the privilege and international focus. And finally, we'll have some tips. So let's get started. First of all, you all don't have access to this, but this, the people who have signed up for this are highly competent in-house counsel for an awful lot of very good franchisors. So you all know what I'm going to tell you, and that is you are living a dual role. Often in your day, I suspect that you're giving legal advice, business advice, they're intertwined. You have to understand, and we'll get into this, the privilege protects confidential communications between a lawyer and client for the purpose of securing and providing legal advice. Now again, business advice, sometimes they intersect, but that is not generally protected. The predominant purpose of the communication has to be legal advice. Now, what does that mean in your day-to-day life? I assume you all participate in operational meetings all day. You participate in analyzing transactions. So let's take an example. Let's say you're in a meeting and it's presented to you that you have an in-house graphic designer and someone asserts, you know, it'd be nice if that individual's salary would be picked up by the marketing fund. Okay, is that a business decision or a communication you might have in that meeting, or is it legal? Well, it depends what you're talking about. But let's say you go beyond the question, should we outsource the graphic designer? Should we try to have the ad fund pay for it? And you go into the specifics. Ladies and gentlemen, in the meeting, I need to go back and look at our documents. I need to look at the FDD, the license agreement, the law. I'm not sure if we can do it under our documentation. That's clearly legal. That's clearly legal advice. That's clearly about your skill set as a lawyer. So then, what I'm telling you here is when you communicate in writing from now on, just be wary of, are there ways I can segregate my communications? Can I make the email about the legal issue and then make a separate email about the business issue? And you may say that's ridiculous, it can't be done. Well, in that case, just try to make the predominant content to be the legal analysis, and that can increase the risk or the likelihood it'll be protected. Another example quickly, let's say your CEO asks you, under our franchise agreement, can we actually require our franchisees to purchase the point of sale product that we just developed on our own nickel? Well, that's pretty easy, that's legal. But then what's the question, if we did that, what would be the reaction of the system, and how would that affect our operations? What would accounting say, are the efficiencies worth the cost from the franchisee's viewpoint? Again, you can start to see that when you have these multiple types of issues involved, you might want to think a moment about how can I segregate communications about them. Now here's your second curse. Who the heck is your client? Generally, if you're an in-house counsel, your client's the corporation. It's not any individual director or an officer or even the other employees. Now, all levels of a corporation and its employees are generally treated as your client as long as the communication is confidential and it's for the purpose of securing legal advice. We can't pound on that enough. It's at the direction of a superior, and the subject matter is within the employee's corporate duties. What does all that mean? It means if the lowest level ops manager has a question and directs it to legal, that's fine, but it has to be generally subject to some director telling that person to do it, and it has to be specifically about a legal issue. The courts generally say the same rationale applies to ex-employees. Now, I have a bullet point here, the control test is dead, except where it's not. Many of you may remember the Upjohn case, Upjohn versus United States, where the emphasis was on what is the control group in a corporation, who is entitled to the protection. And in the Upjohn case, I found that the control test is not generally the majority rule. There are some states that still follow it, but the control test limited the privilege to the corporate officers who play a substantial role in deciding and directing a corporation's legal responses. That would not generally be your operational personnel or your lower level marketing manager. But the majority of courts find that that is not the test. But again, one thing we need to make clear, the attorney-client privilege is generally based on state law, so we cannot tell you in any given state where you're located or where your people are located that the control test is not the law. It is the minority. Some basic 101, the privilege belongs to the corporation. That is the entity that can waive it. And the second point we wanted to talk to you about is who is your client? And one thing you may not have known, I don't want to say that there's a Miranda warning type function, but in Upjohn, it made it clear that when you are talking as in-house counsel with an employee, you need to make sure to protect the privilege, make sure the conversation is relating to the legal function, that you tell the employee that, you know, this question or this answer is regard to the giving of or granting or getting of legal advice. And you may want to actually tell them, you know, the purpose of our meeting here, I'm needing to talk to you so that I can give advice to the corp. Now I'm going to turn it over to Justin, who can talk about the 3 myths.
Thank you, Kirk. And before I begin, I'd like to let the attendees know that to the extent that you have any questions, throughout this webcast, we encourage you to pose those questions to us, and that can be done through the chat function in the lower right-hand corner of the presentation. So good morning or good afternoon, as the case may be. I'm going to begin by discussing 3 common myths associated with the attorney-client privilege as it relates to in-house counsel. And in full disclosure, these are myths that are borrowed from a Law 360 article that Kirk and I came across in preparing for this webcast. We use them here not only because they make salient points on their own, but also because they serve to highlight the issues that are created by the dual role and dual identity conundrums that Kirk just discussed. So the first myth, if you will, is that the privilege applies equally to outside counsel and inside counsel. Now, of course, that's true on its face. The elements of the attorney-client privilege don't change when they're applied to in-house counsel, but what changes is the context in which those elements are applied. In that context is one that recognizes that in-house counsel often play the role of both legal advisor and business advisor. Communications between in-house counsel and corporate employees are, therefore, typically subjected to greater scrutiny than communications between the company and outside counsel. But for that reason, it's all the more important that in-house counsel and corporate employees take particular care to preserve the privilege where possible. And we'll do our best throughout this webcast to provide our thoughts on how to best do that. The second myth is that all corporate employees can have privileged communications with in-house counsel. And again, this is a proposition that is technically true. Corporate employees can have privileged communications with in-house counsel under the circumstances that Kirk just discussed. But bear in mind that in-house counsel represent the company, not its employees. Therefore, whether an employee communication is privileged will largely turn on whether the communication was made for the purpose of securing legal advice for the company, and whether the communication concerned a subject matter within the scope of the employee's corporate duties. And this issue brings up a separate but related issue, and that's how the sharing of privileged communications between lower-level employees is treated. Now, the rule is generally that lower-level employees can share privileged communications with other employees without destroying the privilege, as long as they're doing so to further the purpose of legal advice. That is, those communications that are shared with other employees should only be shared on a need-to-know basis, and the purpose of sharing the communications should be for either the legal advice to be carried out or for the recipient to perform their job functions. Often, an easy way to make it clear that a communication sent by one employee to another is in fact a privileged communication is for the employee to simply forward in-house counsel or outside counsel's advice as the case may be. What becomes more difficult is where an employee attempts to characterize legal advice, and the fact that the communication is in fact conveying legal advice is sometimes lost in what appears to be a business communication. The final myth is one that I suppose we all know is in fact a myth, but we point it out nonetheless, and that's that including in-house counsel or in-house lawyers in a communication creates a privilege. It's amazing how often outside counsel will claim privilege over ordinary business communication simply because in-house counsel has been copied. And by the same token, it's sometimes the case that employees don't appreciate that communications are not protected simply because in-house counsel has been copied. If the predominant purpose of a communication to in-house counsel is in fact to seek legal advice, a few things should be done to make that clear. The first thing is for an employee to address the email to in-house counsel rather than copying in-house counsel among 10 other business employees. The communication should also articulate that it is a communication intended to seek legal advice. And the recipients of the communication should be limited to those that need to know the legal advice that's ultimately rendered or are necessary to carry out the legal advice. And with that, I will turn it back over to Kirk.
Before I go on to the common interest doctrine, which quite frankly deserves quite a bit of attention, I want to go back a bit because, of course, I missed some of my notes. But when we were talking earlier about your role and who your client is, let me just raise a couple of quick examples. Just you lived them, but I think they raise the point. What do you do when a field operations staff member comes in or calls and says, you know what, out in the field, my franchisee's general manager is making noise that I've been sexually harassing her. It's not true. I didn't do anything like that, et cetera, et cetera. Well, instantly, you know, you're in a communication with them. They're an employee of the company. Is it privileged? Well, are they your client? Well, they would be in some respects, but if you are now in a position where they are asking you for legal advice that may be in opposite to the company's interest or whatever, you may have to sit a second and think about it. You may even have to go, if you can't make a decision that second, just hold off. You know what, I'm not sure I'm your attorney, Joe, or whatever. I don't even know if I can be, but let me think about it and get back to you. But that's probably an obvious one. There's another one I thought about is what do you do when your sales development director comes in and says that, you know what, I was entitled to a big bonus this year. I closed X number of deals within the year, and I looked at my check and they're not there, and I found out they were all pushed into the next fiscal year. Nobody told me. I'm madder than heck. You know, well, now you're in an HR position. Again, we're not saying your job is easy, but it often it's worth it to take a deep breath and say, what hat am I wearing? Who is this person? Are they my client? And could there be conflicts arising? So now we'll get back on track and go on and talk about the common interest doctrine. This is something that evolved from not every disclosure of a privileged attorney-client communication will waive the privilege. There are times where it will not. And the common interest document is an exception to that rule. You still have to have otherwise privileged communications. In other words, it must deal with providing legal advice. But this third party and their relationship to your client, the company, may provide the ability to keep those communications confidential and privileged. Here's some keys. The common interest between the franchisor and whoever it is must typically be a legal interest and not a business interest. And generally, the relationship then, it makes sense, there's got to be some sort of joint strategy involved. So what are we talking about? Well, the most common one would be a potential co-defendant or somebody whose interests are aligned with the franchisor in a potential matter, whether it be a supplier, a vendor. We'll talk about even potentially franchisees if there's a common interest. But first of all, some jurisdictions, and again we said earlier, we can't give you a blanket, they actually require pending or threatened litigation for the doctrine to apply. I will call that the old school. The newer school recognizes that in today's world, when you give legal advice to avoid litigation, which is incredibly common, or you're trying to facilitate action to comply with the law, those joint communications with others, they serve the public interest and they should be protected. Now, how do you create this joint common interest? It's different than a joint defense agreement. That's formal. That's primarily when litigation's already been commenced and you're all on the same side of the plaintiff versus defendant ledger. What we're talking about here is much less formal than that. This is relationships that can be with vendors. It can be with typical example, let's say that the franchisor has a sole source supplier, you've given the specs, you work very closely together, and then unfortunately there's some sort of an outbreak, E. coli or anything else, and neither you've named yet, but you both have a common interest about what were the products, what were the specs, how the manufacturing process worked. There are opportunities there where you can communicate with that other party. You can and should, if you can, get a written agreement, but it's not required as long as you can at least produce indicia that that's what the parties understood, that their communications would be protected. At worst, put the heading on the communication, subject to joint interest doctrine, whatever you need to do, just put that on there. But quite frankly, the best advice, short of an actual written agreement, would be at least have an email saying, we understand our communications are privileged, we have a common interest in blah, 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 and therefore we will treat these as subject to the common interest doctrine. Now, the other exception to the rule about sharing privileged communication with third parties is what they call the functional equivalent doctrine. We're still under the common interest doctrine, but this is a little different. This would be third parties that in the way we're working today, are literally de facto employees of the franchisor. In other words, it could be somebody or some entity that's performing the functions that when I grew up would have been performed by the franchisor, the outsourced nation. In other words, have you outsourced some of your marketing roles? Have you outsourced some of your consumer research, handling the website, product development? There are many things today, and the law says that communications with those non-employees can be and should be privileged if they are thoroughly integrated into your operations, and again, it's always the same, and they otherwise fit the attorney-client privilege, that they are for the purpose of obtaining or assessing legal rights. Now, there's another category, which are your actual agents, the franchisor's agents, and these can be consultants, they can be accountants, investigators. The law, and I'll go more financial here, and this is more about your accounting firms, your investment bank firms, your private equity firms. In there, the courts look at, you know what, attorneys aren't CPAs. Attorneys are woefully lacking sometimes in dealing with high finance, and an attorney needs to look to an interpretive ally to interpret all of this not very specialized data and to help to provide, to deliver legal advice. You know, one court was so bold and say, in today's marketplace, attorneys need to be able to have confidential communications with investment bankers to render adequate legal advice. And as Justin will talk to you about a little later, you know, we know in today's world you may be acquired or you may be acquiring. And as in-house counsel, you don't necessarily understand every ratio ever known to man. So you will need to rely on third parties in the financial realm to provide you the information you need to provide legal advice. And now I'm going to turn it over to Justin on the work product doctrine.
So if the purpose of the attorney-client privilege is to encourage full and frank discussions between an attorney and their client at all times, the work product doctrine is slightly narrow in terms of the scope of its timing. The purpose of the work product doctrine is to protect attorneys' work product from adversaries. And with that purpose in mind, there must be an adversarial proceeding on the horizon for the work product doctrine to apply. The doctrine generally protects documents and tangible things prepared in anticipation of litigation by or for a party or its representative. As is clear in the last element, technically the work product need not be prepared at an attorney's direction in order to receive the protection under the doctrine, but it's always a best practice for the attorney to in fact direct the preparation of work product, lest it be considered documents or products prepared in the ordinary course of business, which may not receive the protections of the work product doctrine. Typically, disputes concerning the work product doctrine most often arise under the second element, if you will, of the work product doctrine, and that is whether or not the work product at issue was prepared in anticipation of litigation. And there are really two pieces to that element. There's a timing piece and a motivational piece. The timing piece requires that there have been a real threat of litigation rather than a mere possibility of litigation at the time the work product was prepared. And different jurisdictions have different formulations of that requirement and just how imminent or specific the threat of litigation must be. With respect to the motivational piece, the analysis requires that the primary motivating factor for the creation of work product must have been the anticipated litigation. In other words, was the work product prepared because of the anticipated litigation, or was it prepared in the ordinary course of business? In other words, would it have been prepared regardless of whether or not litigation was imminent? The analysis will often be quite fact-specific as relates to whether or not work product doctrine was created in anticipation of litigation, particularly in the early stages of litigation where you don't have a complaint filed or a demand for arbitration or some other clear indication that litigation will in fact occur. So consider, if you will, two examples. The first is documents that are prepared in connection with a franchisor's internal investigation into a potential violation of disclosure laws. Well, there are a couple of things or facts or scenarios to consider in determining whether or not at that time litigation is reasonably anticipated. For instance, has a franchisee or a prospective franchisee complained about a potential disclosure issue, or is the issue only known internally? Has the franchisor received some sort of complaint from a regulator or from a franchisee? Who is directing the investigation? Is the investigation being directed by in-house counsel or outside counsel, or is it a business-driven investigation? Another example or fact pattern to consider is documents prepared in connection with an internal investigation of a franchisee's potential breach of the franchise agreement. Some things to consider in determining whether or not initial investigation is done in anticipation of litigation is how often do breaches of the franchise agreement result in actual litigation? Does the franchisor have reason to believe that the circumstances that precipitated the investigation at issue were more likely than usual to result in litigation? Has opposing counsel been involved? Does the franchisor routinely perform investigations as a matter of course? And again, who directed the investigation? If the investigation is directed by in-house counsel, that is more likely to be an indication that the investigation was in fact in anticipation of litigation than if the investigation is driven by business employees. Of course, communications related to internal investigations may also be protected by the attorney-client privilege, and Kirk will touch on that topic next. I'd also note that even if communications or documents do receive the protection of the attorney-client privilege or the work product doctrine, it is the communications and the work product that are protected and not the underlying facts contained in the otherwise protected documents or communications. And those facts can be gotten to in litigation through other forms of discovery, including depositions, interrogatories, and document requests. Unlike the attorney-client privilege, the work product doctrine is not absolute. The protection of the work product doctrine can be overcome by a showing of substantial need for the work product, and that the equivalent information cannot be obtained without undue hardship. And that burden is not going to be satisfied if the opposing party can get the information that they seek by, for example, conducting their own witness interviews or through conducting depositions. And in any event, the work product that clearly contains the mental impressions, conclusions, opinions, and legal theories of an attorney go to the core principle of the work product doctrine, and those kinds of work product documents are virtually untouchable. And now we'll move to some examples of applying these principles that we've just discussed to real-world scenarios. Kirk will begin with internal investigations.
Yeah, thanks, Justin. We understand and we know that in your realms as in-house counsel for franchisors, some of you are with small, some of you are with very large. You may have actual departments that do nothing but do audits or do review of compliance. So clearly you've already got probably a very structured function that protects the privilege. But even in that situation, let's take a less large franchisor. As in-house, you may have to investigate personnel issues. You may have to investigate safety issues, product safety. You may have to investigate just pure compliance with standards. I mean, I guess you could spend a lot of time. If you do, though, you got to remember, you're busy people, you delegate this. You delegate it to a non-lawyer. That can still be a protected internal investigation, but it has to be run, managed, controlled by a counsel. And in this scenario, it would be you. If you want to send that to outside counsel, that's the exact same thing. The same rules would apply. But to protect the content of this investigation, which we assume you would want to do under the privilege, it has to be controlled and run out of a lawyer, whether that be formal through a department, the legal department, or you yourself. The purpose of the investigation has to be to provide or obtain legal advice. In other words, it's not to determine what our ROI is on this new product. That may be an internal investigation, but it's not going to be privileged. It has to be about a legal issue. You need to direct it. You can have non-attorneys directing to you or directing to outside counsel, but it has to be a strong line. You can't simply let it run its course and be told at the end, here's our report. And just dovetailing what Justin just said, and we'll say 10 times, whatever the investigation reveals, the facts are not privileged. It's the actual communications, the witness statements, the documents that you found. But ultimately, a fact is not going to be privileged just because you deemed it appropriate to investigate. Strike that. Some tips, though, on how to do this and have a better chance of protecting the privilege. Mark the written materials involved as privileged and confidential. You would think that goes without saying, but sometimes, you know, we all put so many relines in our communications. Half of them are privileged and confidential. It doesn't make it so. But it does make it so when there's a conscious effort to make sure it fits the communication. Restrict the distribution of this internal investigation to those who need to know, particularly inside and outside the company. And it's rare it goes outside the company other than the counsel. Inside the company, it needs to be restricted to reasonable people who have a reason for being involved. Now, thing I didn't know until prepping for this, remember the old Upjohn case I talked about? When there are interviews involving these internal investigations of employees, courts have found that to better protect the privilege in this investigation, the employees need to be told up front the purpose of this interview is for the company to obtain or provide legal advice. It may seem like that's kind of silly, but several decisions have been based on what was told to the employee at the outset of the interview. Finally, and again, this is a theme throughout, many of us may not do it as much as we should, document and communicate the legal purpose of the investigation as often as possible. And that always is what courts talk about hitting them in the head with a bullseye. They often when challenged about privilege, first go to was the purpose to provide legal advice. And you can certainly help that by making the document self-evident. That's enough on that for now. We'll go to our next real-world situation, which will be mergers and acquisition.
Thank you, Kirk. And before I dive into this topic, I'll acknowledge that this is a topic that could probably be the subject of its own webcast, much like some of the other topics that we'll discuss. So this will be a very high-level discussion of some of the things to consider in connection with conversations, or I should say privileged conversations and communications, and in the context of mergers and acquisitions. The topic can be broken down into two issues. The first is the extent to which sharing otherwise privileged communications with third parties, whether that be a potential target of a merger or acquisition, a potential buyer or seller, or whether that be advisors assisting your client in the transaction, advisors such as lenders or accountants. The issue is whether or not those kinds of communications may retain the attorney-client privilege, notwithstanding the fact that the communication contemplates a communication shared with a third party. The second issue is who does the privilege belong to after the deal is done? So we'll take those two issues in turn. With respect to the first issue, sometimes it may be desirable to share privileged information with the other party to a merger or acquisition, but sharing privileged communications with a third party always raises the issue of waiver. Privileged communications that are shared with a prospective buyer or seller may retain privilege under the common interest doctrine that Kirk has previously discussed, but there are a couple of things to know and to do to take advantage of the doctrine. The first thing to know is whether or not the common interest doctrine is even in play. As Kirk discussed, the common interest doctrine requires that there be a shared legal interest, and some jurisdictions require that in order for there to be a shared legal interest, there be pending or threatened litigation. Now, obviously, it's going to be difficult to establish that there's pending or threatened litigation in the context of a merger or acquisition. Other jurisdictions will entertain the possibility that a common legal interest exists in the context of a commercial transaction. So where the common interest doctrine is in fact an option, early documentation is key. The shared legal interest should be documented in a merger agreement perhaps, and it's more likely that it will be determined that there's a shared legal interest the further along the deal is. For instance, if there is in fact a merger agreement in place, rather than early stages of a merger where there are multiple suitors. Another thing to do to potentially take advantage of the common interest doctrine is to document the expectation of confidentiality. And this is a point that we have made and will make over and over again, but one of the key elements of the attorney-client privilege is that the document or that the communication be confidential and remain confidential. So it's important in seeking to take advantage of the common interest doctrine that there be an understanding with any party that privileged communications are going to be shared with, that those documents or communications must be treated as confidential and shared only with those that need to know the information to carry out the advice or to perform their job responsibilities. And there's no guarantee that the doctrine, the common interest doctrine, will apply to communications between a buyer and a seller in the context of a merger or acquisition. So it's important to limit the sharing of privileged communications with a third party to the extent possible. And as just a very brief aside, privileged communications between a parent and a subsidiary will typically maintain the privilege. With respect to privileged communications that are shared with financial advisors or other advisors or consultants on your side, if you will, during a merger or acquisition, those communications may retain the privilege under the agency theory that Kirk has previously discussed. And that is where the involvement of a financial advisor or consultant is necessary to aid counsel in interpreting information to ultimately provide legal advice, as is often the case in dealing with technical issues concerning financing or lending. Those communications shared with third parties may retain the privilege. One thing to do to protect the privilege in that context, if there's an engagement letter with an advisor, is to spell out that the scope of the engagement is to aid in the provision of legal services. And again, absent a guarantee, which there is not, that the privilege will apply, it's important to limit the sharing of privileged communications with third parties to only those communications that must be shared to facilitate the provision of legal advice. And with that, we'll move to the second issue that the merger and acquisition context raises, and that's what happens to the privilege after the closing. Whose privilege is it? As a general rule, the privilege passes to successors when there's a change of control. So consider this hypothetical. After closing, the buyer brings a suit against the seller for fraud in the inducement. Can the buyer discover pre-sale privileged communications between the seller and its counsel, or may the seller claim the privilege? Well, as I've just discussed, the privilege generally passes to the successor. Therefore, the privilege would no longer be the seller's to claim, but rather the buyer's to waive. However, some jurisdictions have found that the seller retains the privilege over communications relating to the merger, that is pre-closing communications related to the merger. But with uncertainty over the law that the jurisdiction will apply, it is important where possible, if you're on the sell side, to consider entering into an agreement with the buyer whereby the seller retains the privilege over pre-closing communications concerning the transaction. And that's the type of agreement that would be incorporated into a merger agreement.
I'm just going to interject here before Justin starts talking about crisis communications. I'm privy to who's on this call, and many of you, unfortunately for all of you and your constituents, have been involved in crises over time, whether they be data breaches or food safety issues or whatever it may be. So many of you could teach this, quite frankly, at a graduate level. If during our talk here, and Justin will get going in a second, but if you've any really pertinent points from your experience, and if you can figure out the chat function, please let us know, because ours will be fairly basic, but I know many of you have lived and died through these experiences, and so I just bring that up.
And Kirk's right. I mean, these days it's becoming increasingly likely that a franchisor will encounter, if it hasn't already encountered, a public relations crisis in one form or another, whether that be a data breach or foodborne illness outbreak or viral negative press. And oftentimes the last thing that a franchisor is thinking about is the extent to which the privilege can be maintained over communications with a third-party public relations firm or other crisis management specialists engaged to assist in crisis management. So it pays to think about these things ahead of time and to have a plan in place. And there are a couple of theories under which franchisors' communications with a PR firm or other specialists may retain the attorney-client privilege. The first is the agency theory. And for that theory to apply, communications with the public relations firm or other specialists must be necessary or highly useful to counsel's provision of legal services, and that advice should not predominantly be for business ends. By way of example, A court handling grand jury subpoenas related to the prosecution of Martha Stewart concluded that communications between Martha Stewart, her counsel, and a PR firm hired by her counsel were primarily for the purpose of facilitating legal services being provided by her counsel. Specifically, the court found that the communications between the PR firm and Ms. Stewart and her attorneys aided the attorneys in developing a legal strategy that included influencing public opinion in the case in a way that would curb prosecutorial aggression. And I'll leave it to the listener to determine how successful that strategy in fact was. But nonetheless, the court found that under those circumstances, it was clear that the public relations firm had been engaged for the purpose of aiding Ms. Stewart's counsel in developing a legal strategy. Another theory under which communications with a public relations firm or other specialists engaged to handle a crisis may retain the privilege is if is under the functional equivalent doctrine, which Kirk has also previously discussed. Now, in order to take advantage of that doctrine, the public relations firm must be so integrated and intimately involved in corporate affairs that they are, in effect, an in-house public relations department making decisions on the corporation's behalf. And if that is the case, then the public relations firm should be communicating directly with counsel. Most courts will tend to analyze the issue under the agency theory, and that is whether or not the public relations firm or a similar specialist has been engaged in order to facilitate the provision of legal advice. Just a couple of practice pointers to consider. The first is, where possible, outside counsel should retain a public relations firm or other specialist and remain as the primary point of contact. Where that is the case, it's a stronger indicator that the engagement is in fact for the purpose of aiding counsel in providing legal advice. Another pointer, the contract between either outside counsel or if it's going to be the corporation that's going to engage the public relations firm, the contract should articulate that the purpose of the engagement is in fact to facilitate the provision of legal advice. Again, as we've said in other circumstances, there should be a confidentiality agreement which makes it clear to any party, any third party, with which confidential communications are going to be shared, that those communications need to be in fact treated as confidential, disseminated only on a need-to-know basis. If a corporation uses a public relations firm regularly, a best practice, if possible, is to engage a new firm, or if you have to stay with the same firm, to segregate the engagements. The issue with working with a firm that the corporation uses sort of on a regular basis for general business practices is that the engagement to deal with the public relations crisis at hand may be more likely to be construed as an extension of the business advice that the public relations firm ordinarily provides to the business. And then the last piece, and this is another theme that runs through all of these real-world scenarios, is that a public relations firm should not be or should only be included on communications where their participation is necessary for the provision of legal advice.
Thanks, Justin. We're going to move on now to my personal favorite, working with insurers. And quite frankly, many of you, almost all of you, I'm sure, have to deal on some level, whether it's daily, weekly, or annually, with issues involving either coverage or actual evaluation of cases, risk management, you name it. But you're dealing with insurance companies. And the general rule is a attorney-client communication communications, again, it has to be with respect to legal issues between you, the insured, assuming the franchisor is the insured, and the insurer are privileged where the insurer is under a duty to defend, and quite frankly, it really means has acknowledged its duty to defend. This also, many times you as the counsel for franchisor, you're not the insured. You're an additional insured under the franchisee's policy. And the additional insured would retain the identical rights. But the problem, and I don't want to say it's a problem, the complication arises where, as many times happens, the carrier is defending under a reservation of rights. Quite frankly, I'd be very hesitant in communicating with the carrier under a reservation of rights scenario with you believing that your communications with the carrier, and not specifically the insurance defense counsel, but the carrier are privileged, because quite frankly, they are in essence denying the fact that they have a duty to cover you and therefore a duty to be your attorney. You may have even obtained your own counsel and your own dime. So this is one, as I said at the outset, our goal is to simply to make your head buzz or your stomach churn a little, but just think about, okay, before I write this very important sentence, will it be privileged? Now, you also are often engaged in positions where you do want to speak, you or your outside counsel, with the franchisee's counsel in confidence. And is it privileged? In a vicarious liability case, are you jointly aligned? But are there conflicts? And again, at this you could write a paper on, and I could speak for an hour. But all I want to say here is always, both you and outside counsel, be very, very careful of thinking about, before you put the email in motion, is to will this be privileged? Because quite frankly, we talked about the common interest doctrine. You may be protected or have an argument under the common interest. You may not. Your interests may not be as aligned. And finally, the joint defense doctrine is very specific. It involves the execution of an agreement. The common interest doctrine, as we talked about, it's a little more informal, but both come into play in the insurance world. Finally, before we get to hopefully the last key bullet points that maybe you can take away at the end of the day, Justin's going to talk about something which I had no idea existed, but we'll talk about international issues.
So before I begin, neither Kirk or I are professing to be experts in international privilege law, and we don't expect in-house counsel to be experts. But it's important for those in-house counsel that work for corporations that do business internationally to be aware that not all countries have the same privilege protections as the United States, and some offer significantly less protection. So the takeaway here is to know the law of the jurisdictions whose law may apply. Now, when a U.S. court is considering what law to apply, it will generally apply the law of the country with a predominant or the most compelling interest in whether a communication remains confidential. Some factors the court will consider are U.S. attorneys involved? Is the client a U.S.-based or a U.S. resident attempting to protect rights under U.S. law? And did the actions at issue take place in the United States? As a general rule, common law jurisdictions such as the United States, the United Kingdom, and Australia, for instance, generally recognize an attorney-client privilege. On the other hand, many civil law jurisdictions, which would include most countries in continental Europe, have narrower protections or no protections at all, particularly with respect to in-house counsel. So again, the important takeaway here is to understand the privilege laws in the jurisdiction where the corporation operates.
All right, thanks, Justin. We're getting near the end. We will honor your time, but we do hope we can give you a couple of, unfortunately, very simple but very worthwhile tips for protecting the privilege. And I have to give you one war story on this because it's not on the screen, but it's very important. Imagine my chagrin when I got a call once from an in-house general counsel for a franchisor during a case, a litigation, and she asked me, you know, does it matter that I didn't pass the bar and our communication's still privileged? I didn't know that. No one knew. I don't think her employer knew that. But basically, the attorney-client privilege often under state law requires a licensed attorney. So that keys into point one. Know the laws of the jurisdictions where we may be dealing with these issues. If you're based in Minnesota, if you're based in Louisiana, if you're based in Washington State, it may have markedly different laws. It might be worthwhile to have someone check that out. The most abused word in our business is confidential. It actually means something. It means it needs to be protected. It is privileged. It should be shared, not commonly, but on a need-to-know basis. We should all start using that word the way it's meant to be, and that is it deems something worthwhile to be protected. I think most of us are good at the next one. Label the communications, whether your favorite moniker is a confidential attorney-client or whatever you want to use. You can use it, you should use it, but just know that label in and of itself does not mean anything. The label has to be appropriate to the communication dealing with the provision of legal advice. This is one that we can all do better in our communication. Take a phrase or a sentence to articulate that the reason I'm writing you, Mr. Marketing Manager, is that I need to learn about XYZ so I can provide legal advice to the company. If the communication, this is the one that every litigator who's ever done business since the internet began will take to their grave, but if the communication seeks legal advice, the lawyer should be in the to line of the email, not the CC. It is the most abused thing in our industry. We all know it. We all see that lawyers are CC'd on everything, and oftentimes the sender believes that by granting putting the lawyer on the CC, they have somehow protected the communication. We should all know that is not the case. Assume the communication will not be privileged, anticipate disclosure. I think this is a thing that we should do more, not all the time, but in big cases, in big issues, and important things in your career, this is one that you may want to think about. When I rewrite this draft letter, how can I write it so if it's Exhibit A to the complaint, it is not harmful to my client? And finally, which is your job and your outside counsel's job and anyone else you want to delegate it to, educate, educate, educate it. Most franchisor employees don't truly understand the privilege, and any reminder, any opportunity that you have to better educate them will pay off tenfold. We thank you very much for participating. As a housekeeping matter, tomorrow, those of you who signed up and attended will receive an email from Gray Plant with a copy or a link to the PowerPoint, and you're also more than able to get this webinar via audio. I think that will be a day or two later, but you can go to our website to the franchise page and that will be available. Justin, thank you very much. Thank you to all who gave us your lunch hour, and we appreciate your time.